few minutes, but I hope it wasn't too tedious for you. Right. Thank you both for your evidence. Do you think the government... Can we crack on straight away? Do you mind cracking on straight away? Do you think the government's got a leg to stand on in being concerned?
Generally, or...
No. In relation to request and publication of papers and legal advice?
I don't think so, Chair. No, I think they don't have a leg to stand on here.
Yeah. Well, you think they're being a bit precious, do you?
I think they are being a bit precious, yeah. I mean, the fact is they have to accept they're a minority government, and that in that situation, when they're taken to account in this way, they may not be able to muster the numbers to avoid being taken to account, and that's just the reality of the legislature holding to account a minority government.
And of course, Nick, would you agree? I'm actually going to ask you a question, but this isn't meant to sound like a statement, but you would agree. The government, there's been actually 9 humble addresses, of which the government have defeated 4 and failed to divide on 5. And Parliament offers salvation to government at times, doesn't it?
Yes, and I think that we have to see the use of the humble address mechanism in context. I mean, yes, it is true that until recently it had been the mid-19th century when it was used, but it's being used in a context where the government had been not voting on opposition day motions and then indeed ignoring them. So the opposition is left then with looking at other procedures that can possibly be used. And just to flesh out really what Joanna said regarding where the government is on this, there were, of course, on the use of the humble address and subsequent contempt motion, it seems to me, a number of safeguards there. The first safeguard was that it was open to the government between the 13th of November, which is when the humble address mechanism was unopposed, and the 4th of December, which is the date of the contempt motion, to have put forward proper compromise proposals if they wanted to, and they did not. Secondly, there's the safeguard of the Speaker having to indicate that there was an arguable case of contempt. And thirdly, there is, of course, the parliamentary majority. It was for the government to vote down. It was obviously the first motion was to try to avoid a vote on the contempt motion itself and refer it here, which was won by 4 votes by the opposition, and then the substantive contempt motion, which was lost. So I do think there are a number of safeguards in place, even in this very particular parliament with its historic issues and the minority government.
So what do you both say to the government's concern that use of humble address could put national security at risk, or perhaps elicit the release of confidential commercial information that could cost UK jobs? Do you believe those concerns hold water in this case?
I think that is overdone. I think that the safeguards I've already referred to are already in place. And we've already had a situation under the humble address where there were regarded to be papers requested that fitted into that category, and that was with the Brexit impact assessments. And the mechanism used there was for the chair of the Brexit Select Committee to look at them. And I think 4 was the number of that were decided in the end that on national security grounds they wouldn't actually be released to members of Parliament. Then subsequently members of Parliament, including myself, Chair, went over to the Department for Exiting the European Union to view them in that controlled environment. So I think there are safeguards already there. The issue for me, and the great surprise, was that for 3.5 weeks the government just sat realising that there were consequences to not complying with the humble address and offered nothing by way of compromise that could have obviated the situation that did arise.
Joanna.
Yeah, I think this point's really well addressed in paragraph 13 of Dr Andrew Defty's written evidence to the committee, where he says it's a fair assumption that neither government nor opposition would deliberately seek to damage national security. There's no reason to suspect that an opposition would be more prepared to do that than the government, and in fact there are far fewer restraints to prevent the government from releasing damaging material than the opposition. And he goes on to make the point that if there were genuine and compelling reasons why the release of papers might cause severe damage to the public interest or be a risk to national security, then there's already mechanisms in place which might be used to try to persuade the opposition to withdraw a motion, for example by sharing material with opposition leaders on Privy Council terms. And of course that would cover both the official opposition and the third party whom I represent.
Okay. And final question, then I'll bring Will in. Your evidence, Nick, talks about Her Majesty's loyal opposition, and I imagine you attach great weight to the word loyalty, that Her Majesty's opposition would not seek to do anything that would undermine the interests of the UK. Am I right in believing that? I think that is presented in your paper as evidence.
Yes, that is our firm evidence, and I'm sure we'll come on to the Law Officers Convention in due course in a moment, but I would point out at this stage that we were, for that reason, very careful in the way that myself and the Shadow Brexit Secretary always presented this, that we were not seeking to undermine the Law Officers Convention, whereby the fact and content of legal advice is private. We always were saying that there is within Erskine May, there is within the Ministerial Code a discretion to release that when ministers see fit. What we wanted ministers to do was to exercise that discretion in these very particular and exceptional circumstances. And I'd say that too is evidence of a sense that we had of being very careful about that convention, its value both now and indeed in the future.
Okay, Will.
Thank you. I just wanted to probe that a little further. Do you think there's any categories of paper that should be off limits to the House?
It's quite difficult to make specific identification in that way. The obvious example, if you want to take your question head on, would be something like national security. However, at the same time, we would want the ISC and other bodies within the House, even in those particular circumstances, to be able to view those papers. So I would be cautious to start categorising things as absolutely off limits, and then realising there's an unintended consequence where there may be a committee of this House that would actually require those documents for its deliberations and judgment.
Okay, Joanna, do you?
Yeah, I mean, I agree. I agree with Nick. I thought I'd never get to say those words, but I think it needs to be looked at on a case-by-case basis.
Yes. And so
it's difficult to identify without being given a specific case, a particular category, and I think the safeguards exist, which I've already referred to.
And so you wouldn't see the need for the House potentially to pass a resolution sort of limiting its scope of what it could request. It would be on a case-by-case basis. Rather than the sort of convention that the opposition parties would not ask for certain things if they had different routes to access them.
I'd be worried about a blanket resolution in that sense, because I think what you would do is you would end up categorising something that a particular committee of this House, and I use the example of the ISC, which on national security is important, but it could be the Home Affairs Select Committee, it could be the Defence Select Committee, it could be any other committee of this House, that actually wanted documents by return and then discover that we had this motion that had been put in place that excluded some of the documents that were quite vital to them, and that's what would concern me about doing that.
Okay, thank you.
So, would I be right thinking that you think the ultimate safeguard is obviously the House of Commons choosing to vote down a humble address and the request contained within?
Yes,
and that would be exercised on a case-by-case basis?
Yes, and it's the majority in the House of Commons on these issues that's absolutely vital. And of course, what actually happened in the case of the key vote here that was won by 4 votes, that was the absolute key. It was the Speaker indicating there was the arguable case, then the subsequent vote. And that vote is always going to be here. And with issues like this, it's not going to be the case that a tiny minority in Parliament with a particular issue in a particular set of documents is ever going to hold sway. It's always going to have to be a majority of members of the House that provides that safeguard.
Helen.
At the beginning, Ms Cherry, your opening sentence was the government needs to come to terms with being a minority government. Could you explain how them being a minority government has an impact on the principle at stake here?
Well, if we go back to why this has all occurred, the government stopped voting on opposition days because it knew it was at risk of being defeated. So where it knew it was going to be defeated, it stopped voting because it didn't have an inbuilt majority.
Yes, but that's not what our inquiry is about. Our inquiry is about whether or not we should have these humble addresses and whether or not they should be, we should seek for the government to publish legal advice.
I appreciate that. But the inquiry takes place against the background of the context as to why the inquiry has arisen. So my view is, as the SNP said in their written evidence to the committee, that we support the use of the humble address. I was simply making the point that this government doesn't have a leg to stand on because of the context in which this has arisen. That's the question I was answering, whether the government has a leg to stand on. Now, on the specific question of legal advice, I want to make it crystal clear that the Scottish National Party have always been consistent in supporting the convention that the law officers do not normally even acknowledge whether or not they've given legal advice, never mind reveal it, unless there are exceptional circumstances. We've argued in the past the invasion of Iraq was an exceptional circumstance because the House was uniquely being given the opportunity to vote on whether or not to go to war. Back in December 2015, we argued that the bombing of Syria was an exceptional circumstance. And in relation to the legal advice on the withdrawal agreement, and particularly the backstop, we argued it was an exceptional set of circumstances because the House was being called to vote upon the withdrawal agreement, which would have major socio-economic consequences for the whole of the United Kingdom. So we've never conceded, we've never gone against the convention. We have recognised that that convention exists, but that it can be waived in exceptional circumstances. In fact, the government themselves conceded that by not dividing on the original motion. And it might be of interest to the committee to know that unlike the UK government's ministerial code, the Scottish government's ministerial code does cover this potential situation of an exception. And it says in paragraph 2.38b, the Law Officer Convention, that the Scottish government, like the UK government, does not, other than in exceptional circumstances, disclose the fact that legal advice has or has not been given to the government by or sought from the law officers or the content of any such advice. So the Scottish Ministerial Code recognises the exception of exceptional circumstances and says that it's something that the UK government also recognises. And I think the fact that the government chose not to divide on this meant that they conceded the point in exceptional circumstances, and indeed I made that very point in the debate on 3rd December.
I want to tease out what in this saga you think is exceptional. Are you saying that what is exceptional is the context and the fact that they were ignoring opposition day debates? Is that what's exceptional?
Evidence. Earlier I talked about the context in which this inquiry is taking place. My evidence on the waiving of the convention on not revealing legal advice relates to the exceptional circumstances which I've just described.
Well, you've said, if I might say so, you said quite a lot. Are you saying what's exceptional is the fact that it was the House taking the decision rather than the Executive?
Yes, that's what I just said. The House was being called upon to vote on the withdrawal agreement, and so the House was entitled to see the legal advice about the withdrawal agreement, particularly about the backstop, which was such a contentious issue. And indeed, as we've seen, because the legal advice about the backstop was revealed, and because the Attorney-General, in my respectful opinion, was commendably frank about his advice when he was questioned about it, we now know that there are very real issues about the backstop.
Okay. Mr. Thomas Simons, when Lord Morris came to give us evidence, he spoke at some length about the special status of legal advice. And he said that he thought legal advice to ministers should be treated like the advice of a family solicitor to an individual. Do you think that's a good analogy?
I do think that's a good analogy, and I've read Lord Morris's evidence, actually, in detail before I came here today. But of course, in that analogous situation, the client has the right to waive privilege, of course, and of course the government technically would be the client in these circumstances. What I would say is that in terms of exceptionality, just address that for a moment, that firstly it's the unique constitutional, political, economic and social implications of Brexit, the withdrawal agreement, and of course the backstop is very much part of that. But the other major concern I had, which I made in my speech in the House on the 3rd of December, was that the previous weekend, aspects of the Attorney-General's advice were being selectively leaked to the press. So, firstly, the fact that the advice existed, well, that part of the convention was breached anyway, because we could see, I think it was the Sunday Times, if I recollect correctly, was covering bits of it on the front page. But also a concern that what this selective leaking meant is that we were having a situation in the House where we were seeing parts of this advice. We knew it existed, but we couldn't actually see the full advice. Now, whilst I'm not saying that goes to the central issue of what is exceptional, I think the central issue of exceptionality was Brexit and the withdrawal agreement itself. But that was obviously a huge aggravating factor in everything, that we knew the advice existed, and secondly, that it was only being appreciated by MPs partially because of the way it was being selectively leaked.
Do you think, I have to say, I didn't think this analogy was at all convincing, because don't you think there's a difference between my private concerns if I'm getting divorced or selling my house and something which is essentially a public interest matter? I mean, how can you draw an analogy with a country solicitor?
I think you're absolutely right to distinguish the two situations. It's the point of comparison I was using was simply the issue of privilege, the issue of confidentiality, legal confidentiality, which clearly, if you went for legal advice, you are entitled to, but you can waive it if you want to. For a particular issue, you wanted to do that. I think in this case, you're absolutely right, there's a wider public interest issue, and that does distinguish it from the country solicitor situation, but it is still the fundamental issue of confidentiality of legal advice. And
why is this advice, why should this advice have a different status from any other advice given by senior civil servants to cabinet ministers?
Well, there's a distinction, first of all, because each department will obviously have its own legal advisors anyway, and then there's obviously the Attorney General's advice. Now, why is its status different in these particular circumstances? I say because of the nature of Brexit, because it is such a huge decision. But I'm not arguing, and this, I think Lord Morris expressed concerns before you, Chair, about the Attorney General being worried about committing certain things to paper on the basis it might end up in the public domain. But of course, that, if I may say so, would be a concern if there was continuously an issue of legal advice being disclosed, but it isn't. This is a truly exceptional situation. And indeed, whilst I don't want to get into the issue of what was actually disclosed in relation to the motion, but what actually ended up being disclosed was something that was very narrow on the Northern Ireland backstop, actually.
Yeah, that's true. Well, what I don't understand is how we're going to decide what's exceptional and what's not exceptional. So, for example, if you are a person who's been denied some benefit and, we've got a lot of very bad cases of people who really are struggling to survive, it's pretty life or death for some of those people. And yet the Department for Work and Pensions will be appealing judgments in the courts all the time. For that group of people who are affected, they would think that was pretty exceptional. But I don't think that you would be asking to waive the Convention on Legal Advice in that case. And I'd like you, maybe you'd both like to respond to this, but I'd like you to say why.
Then we have to take another question ahead, just because we're running out of time.
Sorry.
So, briefly, if you could.
Well, because in that situation, if the constituent had a particular question about the policy that was being applied to them, their MP could ask a question of the Minister for the DWP, and additionally, the constituent has a legal remedy. The point about this situation was the only person who could answer the question we had, about we being the opposition, about the legal advice that had been given about the withdrawal agreement to the government, was the Attorney General. So it's really quite a different situation from the one you described, where there would be a double remedy of taking legal action and also asking questions through the individual's constituency MP.
Just briefly, I think the ultimate answer is obviously a parliamentary majority, which is what I said earlier. That's the ultimate answer as to what will be considered exceptional. But I think in very broad terms, it would be something of profound constitutional, political, social and economic significance, is what I regarded this particular situation to be.
Right, now, Bambas has got to go at 3, so Edward, I'm going to let Bambas ask a very brief question before he goes.
Purely on the example we had today about the revocation of somebody's citizenship or passport, should that advice be disclosed? Or do you think potentially it shouldn't be?
I think the answer to that is no, because, and the reason is that, without commenting on the individual case, that could very clearly end up before the courts in due course. So you would expect always in those circumstances the confidentiality of advice on both sides to be respected.
Janet?
I mean, I agree with that, because clearly from what's being said in the Chamber this afternoon and what's being reported in the newspapers, there's likely to be litigation by the family of this young woman, Ms Begum, and so it will be litigated before the courts. But in this situation, there wasn't going to be any litigation, so there wasn't that remedy or / concern.
Sir Edward?
So, I mean, I was here during the debates on the Iraq War, and I was one of only 17 Tories to vote against it. I seem to remember there was quite a controversy about the Attorney General's advice to government. The House of Commons has not forced the government, I think, according to our brief, to reveal papers against its will since the 19th century. So I'm a bit perplexed at what is so different in terms of national interest, importance, controversy between the Labour government's attitude on revealing the Attorney General's advice on the Iraq War and the Labour opposition's advice on revealing the advice on the withdrawal agreement. I mean, they're both pretty controversial, pretty important, apart from the fact that you're now in opposition, you were then in government, which is a perfectly good answer.
Those two scenarios certainly give rise to different interests, I think it's fair to say. But I mean, obviously I wasn't a member of Parliament at the time of the Iraq War. I think the advice was disclosed. It was in 2005, I think it ends up being disclosed. I think it's disclosed later, but not at the time. But not at the time. The answer on the 150 years, I think I would refer back to my earlier evidence about the issue with opposition day motions. And the reason that we've ended up reaching for the humble address mechanism is looking for something that we felt we could have an impact with in terms of, obviously, robust scrutiny.
No, I can see your frustration. By the way, I spoke up in public against the government not accepting opposition days, and I did argue at the time that I thought it was a dangerous precedent. But I just want to return to this. Let's just focus directly on the Attorney General's advice on two very significant occasions, the Iraq War, this withdrawal agreement. I'm really struggling to see why one is more important, more difficult than the other. My
personal opinion is it's not. My personal opinion is that the Iraq War legal advice should have been disclosed as well. That's my personal opinion, which obviously...
So that is now the official view of the Labour... I'm assuming you now become government sometime, which obviously you will. Eventually you'll be a government. You'll be faced with a situation. You'll get legal advice, which you probably, the attorney will say, it's going to make life very difficult for this to be revealed in the public domain. Because we're, for instance, in a treaty negotiation, what can be more important than that, as we are now on this, or we're in thinking of invading, assuming we've got a Blairite government in the future that's thinking of invading somebody else. So now you're saying in that situation, you believe that you should pretty well always reveal your attorney's advice.
Well, I'm not committing to invading anywhere, but the point I would make is that within Erskine May and the Ministerial Code, that discretion already exists. Yeah. And obviously you would have to make a judgment on a case-by-case basis whether it fits into the kind of issues of the level of significance I previously said. And that's the answer to your question. It would be judged on each particular basis. Right.
But I think we can take it that if we're going to have something which is really difficult and controversial in the future when you're the actual Solicitor General, that your advice is going to be, Labour government, that generally it's a matter of course, although it's discretionary, you believe the Attorney's advice should be revealed. Be careful what you say now.
I think that's... I'm not here to defend our witnesses. You are leading them. I mean, ultimately, Sir Edward, the House divided and decided by a small majority that the that it should be published.
I think the only thing which is different between here and the Iraq War is not the level of interest, the level of importance. The only difference is the fact that this time the government didn't have a majority. Let's be brutally frank about it.
I think it is fair to say that the parliamentary majority in our governmental system is obviously extremely important.
All right, that's a fair answer.
It is, and you know, we parts of our constitution are written, but it isn't codified. Now, we don't have that codified constitution, so without it, the parliamentary majority is very important.
So might is right, really?
Well, my memory's a little hazy, but during the Iraq War, I think the Labour government had a small majority and voluntarily chose to publish
Big majority.
it, didn't it?
Eventually.
No, I was being... Sorry.
Eventually.
facetious there.
Yeah, that you got it right. Didn't you?
2005, I think they published it.
All right. Well, I'm going to say my piece.
Will?
Just if I maybe summarise what I sense from both of you perhaps, it's if Parliament is a protagonist in the decision making, it should have access to the legal advice upon which the business or motion that's put in front of it. Is that what you're saying? Or is there an exception to that?
Well, I think what's happening there is that there's going to be a lot of Attorney General advice on different things. I'm certainly not suggesting that on every single thing that appears before Parliament, the Attorney General could be producing his advice. The point I'm making is really what is in Erskine May in the Ministerial Code, that there will be very exceptional circumstances when that is the case, of which I believe the vote on the withdrawal agreement was one.
I mean, I think a famous English judge once said, and I can't remember who it was, that you can't define what exceptional circumstances are, but you know what they are when you see them. Yeah. And that sounds a bit facetious, but it's correct. So I wouldn't wish to define exceptional circumstances. But I think Sir Edward is correct. The big difference is that the Labour Party at that time, the vote on the Iraq War legal advice, had a very significant majority. This government doesn't. But in fairness to Mick, I've heard many Labour Party members concede retrospectively that legal advice ought to have been released, and those were exceptional circumstances. And that's the position of the SNP Scottish Government that's been in power for the last 11 years or so in Edinburgh, that they don't normally reveal legal advice, but as the ministerial code says, it can be done in exceptional circumstances. But I've just to prepare for this, I was looking at the debate which eventually took place in Parliament at Plaid Cymru's instance, looking at the issue of the legal advice on Iraq after the fact. And some very important points were made in that debate, including by the Right Honourable Alex Salmond, former First Minister, who was then the MP for Banff-and-Buchan. What he said was the fundamental point in this argument was that the party to the decision about whether to go to war was not the government, but Parliament. So the client was Parliament and the people of the country who were entitled to see the legal base on which they were committed to conflict. And he said this was an absolute crucial aspect of the debate, and said that the Foreign Secretary at the time had made great play of the fact that the House was given the unprecedented opportunity to make a decision on whether to go to war. And Mr Salmond said if the House has been called upon to make such a fundamental decision, surely the unavoidable conclusion is that the House, on behalf of the people whom it represents, should be given all possible advice on which to base its decision. And I would say that's a good explanation of why the Iraq War and the decision to leave the European Union with this particular withdrawal agreement the Prime Minister has at present are exceptional circumstances where the House has been called upon in an unprecedented situation to make an enormous decision.
So I won't want to detain you for long. Does anybody else want to ask a question? So let me just read you something from the government evidence that was submitted to us. And I'm just going to quote directly, since we're in the business of quotes. A recent motion for return sought to require the government to provide to Parliament Cabinet subcommittee papers, full stop. The motion was ultimately defeated because a majority across the House recognised that the confidentiality of Cabinet papers was essential to the vital and long-standing constitutional convention of collective Cabinet responsibility. In those two sentences, it seems to me that the government recognises that Parliament can exercise good judgment in individual matters. So if it exercised its good judgment in relation to the publication of Cabinet papers, surely the government might have to accept, it may not have liked the decision reached, that Parliament exercised its good judgment in relation to the release of legal advice around the backstop.
Yes, and I think that illustrates the point I made about the safeguard that there is with a majority in Parliament, because clearly that judgment is a different one from the one that was made about the backstop, and really illustrates the point that the situation as it is, there are safeguards built into the system.
I agree with that.
Right. Does anybody want to ask another question? I think Joanna's got to rush off to another meeting. Does anybody want to... Well, can I then thank you both for coming? An excellent evidence session. I shall now say order, order, so we cease to broadcast. Thank you.
Thank you very much.
The proceeding is currently in private.